Hello, people and peopleettes of the internet. My name is Yirmo, and this is more about where I, fight conformity, and bring you some untraditional opinions because I can. And I also thought it's about time to start showing off more of the design, and since I intend to now do it weekly, call you to we start from here: subscribe, like or dislike, tell me why in the comments, share or donate there if you want me to be able to keep doing this. I know you still don't care about this, but I hope you will with time, because I'm intending to bring some food for thought in this show. And today we have two things to talk about, at least from the news I consumed in the last week. Both of them are about how the Trump administration does a few things I don't really like, as someone who supported him as a right-wing contender, as a conservative, as a free market kind of guy and such. I know you told me in the comments last time he's not really free markets, he's more like populism and stuff, but still, he did do a lot of things that were more free market oriented, at least in his first administration, and the second one is shaping up to be very different. So let's talk about the first thing, which is the attacks on narco-terrorists. And let's bring the lower third. I think this is the key. And go here where I prepared some information about why it is wrong or possibly right. It can be both, depending on how you are looking at it. So the story is well known by now. The Trump administration sent missiles to bomb a ship of drug smugglers in other countries. In this case, I think it was Venezuela, and I think it's the second time they've done this in the past few months. A ship smuggling drugs, allegedly to the US. And I get, as someone who has never smoked anything or sniffed anything, I have no connection to drugs whatsoever. I barely even drink. I get why I don't get, but I'm all for keeping those things out of the US. But can you do it that specific way? Let's see what Perplexity told me when I asked it about the attacks on drug smuggling boats in foreign countries' sovereign waters. The legality of the recent US attacks on suspected drug smuggling boats in foreign or international waters is highly contested, and most independent experts and UN bodies say they do not align with international law or treaty obligations. The US government, however, claims a legal basis grounded in self-defense, counter-terrorism, and drug control treaties. So there is a sharp conflict between the US position and prevailing international legal opinion. I hope the text is big enough. I'll enlarge it even a bit more. Sorry, I'm on the wrong window. I hope you can read it now, because here it looks like it will be very small on phones. Here, this should be enough. 300% zoom. Okay, the US claims the Trump administration has publicly framed the strikes as military operations against narco-terrorists, which is, by the way, not something the Trump administration made up. It's a term that has been used for dozens of years, including by Democrat administrations in the past. And I mean, as far as I oppose having drugs for everyone, not every ship smuggling operation is a terror organization. So this term is problematic, in my opinion, to say the least. Arguing that the cartel's drug flows and associated... Sorry, where was I? Let's start from the beginning. The Trump administration has publicly framed the strikes as military operations against narco-terrorist organizations, arguing that cartel drugs flows and associated violence amount to an armed attack on the United States that justifies the use of force in self-defense. Officials also say the operations are consistent with the law of armed conflict and with international counter-drug cooperation arrangements, asserting that targeting drug boats in international waters is a lawful way to protect Americans from legal narcotics. The only problem is these claims don't align with what actually happened. The attack was not executed on international waters. It was done while the vessel was still in another country's sovereign waters. So this is not international waters. And if the US waited a few hours for the same boat to be in international waters, it would have been fine, in my opinion. But in this case, it was not. And that is not fine. What the international law generally requires. Under the UN Charter, a state may use force on or against another state's territory, like happened on this case, only with that state's consent, which it didn't get in this case, under a UN Security Council mandate, or in self-defense against an actual or imminent armed attack, which this is not because it takes the drugs time to arrive to the US via boat. Drug trafficking, even when deadly in its consequences, is usually treated as a serious transnational crime and a law enforcement matter, not as an armed attack that allows cross-border or high-seas military strike. Which aligns with my opinion on the matter, because it makes sense. You can attack narco-terrorists, so-called, but do it when they are in international waters. You cannot. This was an attack on another country by design. I mean, it was. People say it was like done as a way to threaten the local government, to tell them the Trump administration is not happy with them and is intending to cause a coup in that country. But that does not excuse an attack like this. You can attack the country if you're at war with it or something, but you're not at war with the country. You claim you're at war with a narco-terrorists, so attack them when they go out of that sovereign country. Human rights and law enforcement standards. Outside an armed conflict, the governing standard is international human rights law, which permits intentional lethal force only as a last resort when a person poses an imminent threat to life and no lesser means will work. Which clearly in this case it was not. It was not imminent. You could wait a few hours. UN human rights officials have said that based on information available, people on the targeted boats did not appear to present an imminent threat, justifying being killed at sea instead of being intercepted and arrested, and have described the strikes as unlawful extrajudicial executions. I disagree with that analysis, because with the last part of it, I think it was illegal because it was done, again, before they were in international waters. I have no problem with extrajudicial executions if they would have happened in international waters. Does the armed conflict frame fit? Most independent legal scholars and NGOs argue there is no recognized international armed conflict between the US and drug cartels, so the law of armed conflict, which allows targeting fighters, does not apply. From that perspective, characterizing traffickers as unlawful combatants or treating drug boats as military targets is viewed as an effort to bypass the stricter human rights and law enforcement rules that should govern such operations. I agree with that part, definitely. When a government goes to extreme wording of anything, like laws, like targets, like goals, it's always an excuse to justify an overreach, which will be in the next lower third for the next part of the show. Overall alignment with international obligations, because the operations have not been authorized by the UN Security Council, lack clear consent from affected coastal states, and do not fit the widely accepted threshold for self-defense, UN officials and many experts say the strikes breach the UN Charter and the US Human Rights Treaty obligations. In short, while the US asserts a legal rationale, the prevailing international view is that these attacks are not compatible with international law, and that suspected traffickers should be intercepted, investigated, and prosecuted rather than summarily killed at sea. Again, the first part of that analysis is right. You shouldn't attack them on another country's premises. You can attack them once they're in international law, not just to intercept, but also to kill. But you should wait until they're out of the country of origin, because otherwise it's an attack on another sovereign country. So I asked a follow-up question. What international laws govern use of lethal force at sea? Because it wasn't clear enough to me. And Perplexity answered, international law limits when and how states can use lethal force at sea. That was in the previous answer. Core legal frameworks. The main sources are the UN Charter, the UN Convention on the Law of the Sea, which is called the UN Clause, international human rights law, and international humanitarian law. Customary international law and soft law instruments like the San Remo Manual and armed conflict help interpret how these rules apply in practice. So we did see the UN Charter rules on force, I think, in the previous. Any lethal strike here, this part, any lethal strike at sea that qualifies as a use of force must meet necessity and proportionality and cannot violate the sovereignty or territorial integrity of other states without a valid legal basis. Once it's in international waters, it's questionable if you can kill the terrorists. But you see, I'm using the Trump administration phrasing because I don't argue with the phrasing, even though I know it was invented to justify overreach. But I like the goal, so it aligns with my personal opinions. So I don't have a problem with using that, even though it's not true. They're not terrorists. They are criminals, very dangerous criminals, but they are not terrorists. But this was important. The UN clause says the high seas are reserved for peaceful purposes and that ships on the high seas are generally under the exclusive jurisdiction of their flag state. Other states may only stop on or board foreign vessels in narrow causes such as piracy, slave trading, stateless ships, or with flag state consent. And even then, any use of force must be strictly necessary and minimized. I think this phrasing doesn't make sense. You should be allowed to attack a ship of people that are engaging in very dangerous activity like pirates without consent from the flag country, because the flag country, once the ship is not in the country's waters, the flag country has no connection with it. Law enforcement and human rights in peacetime operations, for example, anti-smuggling or fisheries enforcement. The governing standard is law enforcement and human rights law, not the law of war. Lethal force is permitted only as a last resort, when strictly necessary to protect life from an imminent threat and when lesser means are insufficient. In this case, this is questionable. It is, are we in peacetime or wartime when it comes to drugs? Because drugs are killing a lot of people in the US, so the US can claim it's a wartime, like the war on terror, where now the war on drugs. So this is, I can roll with Trump's administration, claim that it is more a matter of laws of war than peaceful times. If there is an armed conflict, international humanitarian law and the law of naval warfare apply, as reflected in the San Remo Manual and the Geneva Conventions. Even then, attacks must be limited to military objectives, respect distinction and proportionality, and it is expressly forbidden to deny survivors or conduct indiscriminate attacks on civilian vessels. This is not civilian vessels. This is again, narco-terrorist vessel. These are criminals. These are not just civilians. So according to the law of war, even though the UN and Perplexity are choosing to apply it in a very strict manner here, I think it's totally fine under the law of war that the Trump administration is attacking drug smuggling boats. Again, at least when it's in international water. In Venezuelans' jurisdiction, I'm not so sure that's all right. Okay, the second part of the show. Let's bring up the... oh, I didn't have it ready. Sorry. Let's see quickly because you can already see it on the screen. Okay. Let's have the lower third bring us to the second part. This week, President Trump tried to limit states' powers in regulating AI innovation under their jurisdiction. And he was, even his own senators said, wait, you're going too far with this. So I asked Perplexity if President Trump can sign an EO, an executive order, forbidding states in the US from regulating something that is not mentioned in the Constitution and is in no way reminiscent of the Constitution. Because the Constitution promises, ensures one thing: the states have powers over what happens in the states. Washington, D.C. only has general power over very basic general things, and AI shouldn't be one of them, I think. Let's see what Perplexity says about that. President Trump's recent executive order aimed at blocking or discouraging state-level regulation of artificial intelligence raises serious constitutional questions and is very unlikely to operate as a blanket, self-executing ban on state AI laws. It mainly sets up federal litigation and funding pressure rather than actually changing the constitutional balance by itself, because he cannot. An executive order does not change the Constitution or makes AI cover, be covered by the Constitution, because it is not. The Constitution was written almost 300 years before AI existed. I mean, 240, what is it, 7? From 1776 to 2022, I think ChatGPT launched. I think that's about 245, 6. What the executive order does: the order declares a national policy favoring a single, minimally burdensome federal framework for AI and characterizes stricter state AI rules as obstacles to national interests and interstate commerce. It directs federal agencies, especially Department of Justice, FTC, which is the federal, I don't remember, FCC, which is the bank, I think, and commerce, to identify onerous state AI laws, sue states to block those laws, which is completely bananas. The federal government is going to sue local administrations for laws that are constitutionally allowed. This is crazy. And threatens to withhold certain federal funds from states that persist. Let's skip that and go straight to the limits. Constitutional limits on the executive order. Courts have generally held that preemption must come from the Constitution itself, a federal statute or valid federal regulations authorized by statute, not simply from a presidential policy statement. So when you want to pass something like this, like general federal limits on AI or limits on limits for AI, you should be more based on the very basic laws of the US, not just a whim of the president. Using the threat of cutting off federal funds, like Trump is doing, is constrained by constitutional conditions on spending doctrine. Conditions must be clearly stated, related to the program, and not too so coercive that they effectively force states to surrender the reserved powers, which this executive order totally does. Arguments supporting the executive order. Dormant commerce clause theory. Aggressive divergence state AI rules, for example, on access, transparency, model behavior, unconstitutionally burden interstate commerce in AI services and infrastructure. So this claim says if there is too much difference between AI regulations in different states, it makes the connection between states in the US more difficult and practically renders them not part of the union. Agent authority. Existing federal statutes, like those governing the FTC and FCC, may allow agencies to adopt rules or interpretations that preempt conflicting state requirements, especially where AI is tied to communications and consumer protection. This is understandable. Need for uniformity and national standard is said to reduce compliance costs and encourage innovation, which supporters view as a core national interest the federal government is entitled to protect. So what the goal here is to allow the US to adopt AI in faster way than China, which is funny because AI is being used mainly right now to enforce Chinese-like undemocratic, privacy-busting, socially coerced standards without without citizens having any say. Arguments opposing the executive order. No independent preemption power. An executive order cannot itself be supreme law of the land. Without a specific statute, there is nothing for the executive order to rest preemption on beyond the president's policy preferences, and that's true. Trump is making federal law just on a whim, which is not how the US is supposed to work. And it's very clear in the Constitution that the founders did not want such things to happen. Not that they never had happened, but the founders were very opposed to that. Federalism in the state police powers. States have traditional authority to regulate discrimination, workplace conditions, privacy, and consumer protection. Using AI does not automatically federalize those domains. And coercive funding threats. Cutting broadband or other key funding to force states to relax AI rules risks being seen as unconstitutionally coercive, similar to concerns the Supreme Court raised when the federal government threatened to withdraw existing Medicaid funds in NFIB versus Sebelius. So, what this means, I think I talked about it enough generally. So the bottom line, as written, the executive order is best understood as a litigation and pressure strategy, not a measure that instantly nullifies state AI laws, which again, it is constitutionally allowed, but it's very it's not something that should happen too often. Which remains in force unless court enjoins them or Congress enacts preemptive legislation. Many constitutional scholars expect key parts, especially any claim that the order itself bans state AI regulation or uses funding threats too aggressively, to be vulnerable in courts and unlikely to be upheld as a broad standalone limitation on state powers. So the expectation here is that there will be some power to this executive order to tell states, be careful what you pass as laws against AI innovation, etc. But the court probably won't nullify the executive order, but it also won't give it the power to make states completely bow to the federal government and not pass any laws on AI, because this won't be constitutional. I mean, you can threaten states. It can be a wide threat, like the Trump administration does very often. This is not something that should be allowed. The Constitution doesn't forbid it, but it's very questionable. It's a questionable practice that shouldn't be happening. It's very clear the founders did not want such things to happen in the US. And again, in the current state of AI, what happens eventually is this is only used to give companies an excuse, the companies and the government, an excuse to make AI be used in a way that is undemocratic, because there is no limit on what AI can do if the federal government forbids states from protecting citizens from AI. I think this is enough about that. You'll see me next week. Goodbye.